Hello and welcome everyone to the Polity Primer series of Drishti IAS. My name is Pragya. In today's insightful episode of Polity Primer, we are going to discuss yet another important constitutional amendment act, and we are also going to try to find an answer to a very important question, that can Parliament by way of an constitutional amendment under Article 368 of the Indian Constitution take away or abridge your fundamental rights? The title of our today's discussion is the 24th Constitutional Amendment Act. In this discussion, we are firstly going to study about what is the 24th Constitutional Amendment Act. Then we are also going to understand its historical background. Then we are also going to see the key provisions of the Constitutional Amendment Act, 24th Constitutional Amendment Act. And lastly, we will be seeing some of the questions for your preliminary examination and a question for your mains examination. So, if I talk about the 24th Constitutional Amendment Act, this becomes very significant in the constitutional history, because after this amendment, the constitutional landscape started to change in India. Basically, it established the supremacy of Parliament over the judiciary. So, the 24th Constitutional Amendment Act was brought in response to the Golaknath ruling of 1967 of the Honorable Supreme Court, which held that the Parliament does not have the power to take away any fundamental rights through amendment to the Constitution. So, let me explain to you a brief historical background, because otherwise it would be very difficult for you to understand. So, if I talk about the historical background or background behind the enactment of the 24th Constitutional Amendment Act, you remember that first Constitutional Amendment Act happened, and which basically tried to bring agrarian reforms in India. Agrarian reforms in India. And it basically also talked about giving reservation to the socially and economically backward classes. So, this first Constitutional Amendment Act was challenged in the Supreme Court in the landmark case of Shankari Prasad versus Union of India. Okay, so the basic issue or the basic point of tussle between the Parliament and judiciary was the supremacy of fundamental rights over the directive principles of state policy, because Article 37 of the Indian Constitution clearly states that the directive principles of state policy are not justiciable in nature. But at that point of time, agrarian reforms were required, because our Prime Minister, then Prime Minister Pandit Jawaharlal Nehru, had a very socialist bent of mind. And it was necessary also because we had to abolish the zamindari system. Okay, so the important legal question that was involved in the Shankari Prasad case was whether a constitutional amendment act, whether a constitutional amendment under Article 368 is a law for the purposes of Article 13. For the purposes of Article 13. So, this was the legal question that was involved in the Shankari Prasad versus Union of India case, that is a constitutional amendment under Article 368, a law for the purpose of Article 13, because previously we did not have this statement that constitutional amendments are not considered to be law for the purposes of Article 13. So, this was the legal question that was involved in the Shankari Prasad versus Union of India case. And in this case, the Supreme Court agreed with the argument of the Parliament that Article 13 and Article 368. Okay, so Article 13 and Article 368 are basically two different powers. Okay, Article 13 says that you cannot take away or abridge any fundamental right. On the other hand, Article 368 gives the amendment power to the Parliament. So if the Parliament has the amendment power, definitely it can amend the Constitution, and it includes amendment of Article 13 as well. So this was being argued on the side of Parliament in the Shankari Prasad versus Union of India case, and the Supreme Court agreed that yes, Article 13 and Article 368 are different. Parliament has the power to amend the whole of the Constitution, and which includes the fundamental right as well. So basically it agreed that Article 13 had no control over Article 368. So basically in this case the Supreme Court gave a ruling in favor of the Parliament. So if I talk about the historical background, like after what happened after the enactment and of first Constitutional Amendment Act, and after what happened, there came the 17th Constitutional Amendment Act. Okay, so the 17th Constitutional Amendment Act was also challenged before the Supreme Court on the same ground that no, you cannot enact any constitutional amendment which takes away or abridges the fundamental rights of the people. So this was challenged in the Supreme Court in the Sajjan Singh case. So the Supreme Court, upholding the validity of the 17th Amendment, held that the Parliament has the authority to amend any part of the Constitution, including any fundamental right. So basically it reiterated its stance in the Shankari Prasad versus Union of India case, in the Sajjan Singh case as well. But after this, the I.C. Golaknath case came up before the Honorable Supreme Court of India, and this changed the whole scenario regarding the tussle between the Parliament and the judiciary on that focal legal question, that is a constitutional amendment a law for the purposes of Article 13. So basically the Supreme Court in this case by 6:5 majority held that Parliament has no power to amend the fundamental rights. That means Article 368 also comes within the purview of Article 13. Okay, so it also comes within the purview of Article 13, and Article 13 definitely can control the Parliament's amendment power under Article 368 if the Parliament is trying to take away the fundamental rights of the citizens. So this ruling basically changed the stance of Supreme Court that they had taken in the Shankari Prasad and the Sajjan Singh case. This case also talked about the doctrine of prospective overruling, because it came in the year 1967 and agrarian reforms were going on. We already had the first Constitutional Amendment Act, we already had the 17th Constitutional Amendment Act, and this judgment, applying this judgment retrospectively meant undoing all of the reforms which had been done since the last 20 years. So the Supreme Court took cognizance of this fact and said that no, we will not apply this judgment retrospectively, we will apply this judgment prospectively in nature. That means the reforms, the agrarian reforms which are already done were left untouched by this judgment. Moving forward to the key provisions of the 24th Constitutional Amendment Act. So it restored the absolute power of the Parliament to amend any part of the Constitution, including Part 3, that is the fundamental rights. So as I have explained to you and as I have mentioned to you before also, that yes, this Amendment Act came to nullify the judgment of the Honorable Supreme Court in the I.C. Golaknath case, and that is why it said that no, Parliament has absolute power under Article 368 to amend any part of the Indian Constitution, including the fundamental rights. That means Article 368 can amend Article 13 as well. The Act provides that when a Constitution Amendment Bill passed by both houses of Parliament is presented to the President for his assent, he should give his assent. That means the President is duty bound to give his assent to any constitutional amendment bill if it has been passed by the Lok Sabha and the Rajya Sabha. The President was made duty bound, as I have explained. Okay, moving forward. It amends Article 13 of the Constitution to make it inapplicable to any amendment of the Constitution under Article 368, and that is why you will see this phrase in Article 13 that Constitutional Amendment Acts are not considered as law for the provisions of Article 13 of our Indian Constitution. So basically Article 13 clause 4 and 368 clause 3 were inserted through the 24th Amendment. And Article 13 for clause 4 clearly says that nothing in this article, that means Article 13, shall apply to any amendment of this Constitution made under Article 368. That means clearly that Article 13 has no control over Article 368. It cannot apply over Article 368. And definitely this gave Parliament a supremacy over the judiciary, a Parliament an absolute power to amend any part of our Indian Constitution, including the fundamental rights. Moving forward, Article 368's marginal title was changed to Power of the Parliament to amend the Constitution and Procedure, from Procedure for Amendment of the Constitution consequently. And notwithstanding anything in the Constitution, the Parliament may, in the exercise of its given constitutional power to be amended by way of disparity, addition or repeal, any constitutional provisions in accordance with the procedure create forth in this article has been added to Article 368. That means this is a saving clause which protects any constitutional amendment act from the scrutiny of Article 13. You cannot challenge it on the ground that, okay, my fundamental right is violated. The Parliament has the power to take away your fundamental rights, okay, and this amendment made it clear. Moving forward, so basically the 24th Constitutional Amendment was very important in nature because it established a parliamentary supremacy over the judiciary. It said that yes, Parliament has the amending power over the whole Constitution and the judiciary cannot scrutinize its power over the ground that it has violated some of the fundamental right, and definitely the Parliament had the intention to make the DPSPs justiciable in nature because they were planning reforms in India. At that point of time, our country needed some reforms to be done. So with this, we come to a conclusion of our today's discussion. We have discussed what was the Constitutional 24th Amendment Act. We have also seen the historical background behind it, the three landmark rulings of the Supreme Court in Shankri Prasad versus Union of India, Sajan Singh versus Union of India, and I.C. Golaknath versus Union of India. We have also understood the key provisions of the 24th Constitutional Amendment Act. Now, let us reveal the answer for your previous practice question which I asked in the previous session. So, the question was, preamble is not a part of the Indian Constitution. This was held in the case of option A was the Berubari Union case, option B was I.C. Golaknath versus State of Punjab case. Option C was Keshwanand Bharti case and option D was none of the above. So your correct answer will be Berubari Union case, and if you are not able to connect or know the answer, kindly watch that episode on the 9th Constitutional Amendment Act, okay, to find out the correct answer and why this is the correct answer. Moving forward to the practice question for prelims for this session. So the question is, consider the following statements. Your statement number 1 is, the 24th Constitutional Amendment Act was enacted to reverse the Supreme Court judgment in the I.C. Golaknath case. Your statement number 2 is, it made President's assent compulsory for any amendment. Which of the statements given above are correct? Your options are, option A is 1 only, option B is 2 only, option C is both 1 and 2, and option D is none of the above. So, I am revealing the correct answer for you. Your correct answer will be option A, statement 1 only, because it made President's assent compulsory for only the Constitutional Amendment Bill and not for any other amendment. Okay. So kindly keep this in mind and don't get confused in the examination. Now let us discuss a practice question for your mains examination. So the question is, discuss the significance of the 24th Constitutional Amendment Act. You will, in the introduction, you will write about the constitutional 24th Amendment Act, that yes, it was there to overturn the judgment of the Honorable Supreme Court in the IC Golaknath case. You will explain what happened in the first amendment in very brief. You will explain that yes, the first Constitutional Amendment Act was challenged in the Shankari Prasad case. You will write the legal question that was a focal point of tussle between the Parliament and judiciary. You will write about the Sajjan Singh case, IC Golaknath case, and you will write the key provisions of the 24th Constitutional Amendment Act, and you can conclude very holistically that yes, this was a watershed movement in the Indian Constitution, because after this, the landscape of our Indian Constitution started changing. And you will also write that this Constitutional Amendment Act was finally approved by the Honorable Supreme Court in the Keshwanand Bharti case. So you will just mention this and you will conclude that yes, it was a very important Constitutional Amendment Act which definitely established the parliamentary supremacy over the judiciary. So you can conclude very holistically. I hope this session was insightful for you. If you have any feedback regarding this session, kindly drop it in the comment box below. If you liked today's discussion and found it to be helpful, kindly like the video and subscribe to our channel for more such updates. If you want the PDF of this session, you can join our Telegram channel, the link of which is given in the description box below. Thank you.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.